And last time we left off with the case, Coils, his motion, who is the owner of NoPixel, or one of them now that he sold it to XQC and Buddha, he owns 50%, everyone else owns 25%. He wanted to dismiss it, and the court said no.
Nope.
No, we're not dismissing it because Tove, which is a company, that one video game company, hired a foreigner under a work visa, and that guy under the work visa went to work for Coil and developed some code, and part of the work guy's contract was anything that he develops they own. So now Tove is suing Coil for, I hate to say it, but half the company. But Coil, as you're going to see, it's going to say, no, it's not half the company, but like half the revenue from these 4 servers. And we're going to get into that. So, this is where the court says, hey, look, there is a controversy. We get that it's not copyright infringement, but the court finds that Tove is asserting a claim for joint ownership under copyright law. So they're saying, hey, that work that they did is owned by them. And when we get into it, guys, a piece of me does feel bad for Coil, but this is going to be a huge learning lesson. And some of these learning lessons are tough. Okay, so this is the NoPixel motion for evidence, and we had a little update a couple months ago when this came out, and this is from Coil himself.
That's all good though. How's the court case going? I got no fucking idea where it's at, honestly. Well, we're not 100% sure, but still confusing. But if there's any updates, I'll be sure to let you guys know. All I know is the legal system, well, you know what? I'll just wait. We'll just wait.
Look, man, he is not doing good in this lawsuit. I'm just telling you that straight up. The fact that he couldn't get it dismissed, and when you start to see what's happening in this lawsuit, this guy is making, like I said, easily over $100,000 a month, if not 5 times as much.
We'll just wait. It's strange how it works. And, obviously, I don't understand the ins and outs of it, so. Must be so draining. Honestly, it's not. It really isn't draining. It seemed daunting at the start, but like, if you have good lawyers and you talk to them and understand what's happening, and you have the truth.
Now, the truth is very murky, but he does have Larry mother effing Zerner out there, and Larry is giving them hell, but despite Coil having the truth, I would say from the outside looking in, the evidence may not be fully on his side. And you're going to see that.
It's not that worrying. It really isn't. I'm chilling.
Now, he may be chilling 4 months ago, but the case has changed so much. As far as trouble, he's not too much in trouble. He's just about to lose. He potentially could lose a lot of money, but he threw another Hail Mary, which we're going to actually get to later.
Wait for it. Yeah, I mean, yeah, I don't know what phase. I think it's like discovery or some bullshit. I don't know what that means specifically, time frames, all that sort of stuff. But that's like where it's at this point. So
discovery is when you ask for information and I ask you for information. So this is where we at right now. This is Coil's supplemental memorandum for a motion to compel for documents. Okay. So basically, if someone files a motion to compel, they're filing a motion to make you produce documents. All right, so that's what this is. And, whether they allege when plaintiff's attorney filed the joint stipulation regarding motion to compel production of documents, it appears that the declarations of Larry Zerner and Mitchell Clout were referred to in the motion, which were sent to Tove's attorney, and they were omitted. So you're like, well, how would they omit that? Okay, Larry Zerner signs it, but let's look. Coils, this is the declaration of Mitchell Clout. This is the owner. Now you're about to finally get the full backstory from his mouth of how he got into business with DW from his mouth only. So, hey, my name is Mitchell Clout. I am, I run Coil. Coil's a company based in Australia. It runs NoPixel. It's a game server for GTA. The NoPixel server allows gamers from all over the world to log in and play cooperatively and competitively against others and video gamers. Many of Coil's servers are free and open to the public. However, because each server, which is just a computer, can only handle a limited number of gamers at any one time, typically around 250, and because there are sometimes thousands of people waiting in line to enter a particular server, Coil allows people to pay to get priority to get into the server sooner before the people who haven't paid anything. So it's like a super chat in your way into it. Now, these people are paying anywhere from approximately $50 a month to $200 a month for better access to each server. Now, later in the court docs, you're going to see roughly around 700,000 people are playing this game. So the money adds up, especially if, everyone's paying $50 a month. But, a good analogy would be, what an airline does for a flight. Just as people can pay lower fare and get the center seat in the back of the plane, travelers can pay extra for a window aisle seat to be closer to the front of the plane or to fly a business first class. Coil offers gamers extra service and faster entry into servers depending on their monthly payment. So look, it's paid for access, okay? it's paid for access. All right. In May 2021, Coil entered into a contract with Daniel Tracy for Tracy to work as a developer. Daniel Tracy is also known as DW. Coil paid Tracy a base salary of $10,000 per month. That's just base salary. All right. In March 2022, Tracy proposed doing extra services in exchange for additional money. All right. From Coil. One of the things that Coil asked Tracy to do was set up additional international servers because at the time, the only international server was in India. Coil and Tracy communicated through the Discord messaging app. On March 22nd, 2022, Tracy sent the terms of his employment proposal. A true, correct copy of this message is attached as Exhibit 1. You're going to see the messages. You're going to see the alleged proposed terms, okay? In the message, Tracy outlines the terms of his employment. First, Tracy sets out the scope of his work in a section called primary responsibilities. That's a big hard pass. Nope.
Nope.
I don't know what that is, shooter. So some of his responsibilities include leading infrastructure team, ensuring server setup stability, setup time, security, all these different things, right? Now, fourth, and most importantly, he lists pay, which says base 10K, revenue splits, current revenue splits 50% India, 50% whitelist priority, including Lotto, and 50% all international servers' ability to add revenue split at any time. Tracy then writes contract renegotiation sick every 6 months. This just adds/removes revenue splits that were arranged in those 6 months in the next contract if needed. Okay. In this message, Tracy was stating that he would accept $10,000 per month as his base pay, plus 50% of revenue from the existing India server, 50% from the Coil whitelist priority server, and 50% from the international servers, which would help get a lot online. And Shooter Torres doubles down and says, in all honesty, these people want to be JDF so bad. That's a truthful statement.
That's a truthful statement.
That is true. The whitelist priority server was a small server which was only open to people who applied and were accepted by Coil, as opposed to the other servers which were open to everyone. The whitelist priority server was mainly used by content creators such as gamers who would stream their gameplay on Twitch, YouTube, and other live streamers. This is where XQC plays, guys. So if you ever see him playing GTArp, he's playing on a whitelisted server with all the other top creators. Now, Tracy eventually helped get 2 additional international servers online besides India, one for Spain, and one that covered South America running Coil's code. Emphasis on Coil's code. Coil paid Tracy 50% of the revenue from these servers, which typically average between $40,000 and $50,000 per month to Tracy until Tracy was terminated in 2022, December 2022. So he is making, on the average, $10,000 base salary plus $20,000 to $25,000 per month from the servers he set up. This is a lot of money, guys. A lot of money. It's an easy bag. At no point did Tracy ever ask for or receive any money from any servers other than the 4 agreed ones, i.e. whitelist priority, India, South America, and Spain. At no point did I ever ask to speak to anyone at Tove or agree to pay Tove or Tracy money from any other server. I've agreed to give DW, or I have agreed to give plaintiff the revenue statements for the 4 servers that I agreed to pay for Tracy for. As there were never any agreement, and Tove does not allege that there was an agreement to pay Tracy or Tove for the revenue from other than these 4 servers, I do not understand why I'm being asked to provide revenue information for these other servers. They are completely outside the scope of the agreement. So what's happening is this lawsuit has come up. They said, we want to see revenue from all the servers. He like, well, I only agreed to these 4 servers, so why should I give you revenue from all 4? Well, Tove wants, to see as much money as Coil bringing in. So, he declares under perjury that this is signed and true. Now we about to go to the evidence. Man, I love some good evidence. So here, it outlines his responsibilities. There's no need for me to read all these. You guys can screenshot this, pause it, and come back. But when we go down, the base salary is something we do need to take a look at. Okay, so this is not an official contract, and this is going to come up. Unfortunately, it's not a contract, but it does outline the splits, the 10K plus 50% of India, 50% of whitelist, 50% of all international servers, and the ability to add revenue split at any time. Minimum revenue split is 20K. So like I said, those servers are making anywhere between 20 to 40K out there. All right. So let's keep going. There goes your contract renegotiations are every 6 months. Let's keep going. So we keep going. This is like basically Larry Zerner saying like everything is true. Now we got more exhibits. Now, this was never mentioned or anything, but there was a potential defamation lawsuit at play because when DW quit from working for Coil, Coil said, hey, there was a breach and blamed the breach on Coil. So what does he say? Mr. Clout, they're reaching out to him, demand to immediately cease and desist. This is what a real cease and desist letter looks like from someone who is about to bring legal action. And we've covered defamation cases. This is what you need for the start of it. You need to say, hey, I need you to stop making this false statement, which you have to say which statement is false. And 2, it just documents like what you want them to do. So, hey, our office has been retained by litigation counsel to Danny DW regarding various false and defamatory statements you've made about him, both individually and via the Grand Theft Auto 5 and the game roleplay server entitled NoPixel, according and pursuant to the California Discovery Act. Okay. I see the 20K from the server is crazy. It is crazy. But now when we get later into it, it's way more money. It's way more money, man. Way more money at stake. Okay. As you know, Tracy is a software designer. They kind of glaze him. They glaze DW right here. And they say it comes to our attention that about, December 28th, you inexplicably removed Tracy from the NoPixel server community, which removal was visible to all other community members. Therefore, you caused the NoPixel server to issue a demonstrably false statement that a former NoPixel employee had allegedly caused this data breach. Okay, so there is your quote unquote false statement that's needed for defamation. Say, hey, this person caused a data breach. Unless you got like inexplicably proof of it. If you don't, you can find yourself on the bitter end of a lawsuit. Following such a public statement, you also made further false statements in your personal capacity to the NoPixel staff, as well as general public via Twitch. Collectively, the defamatory statements which identified Mr. Tracy as the former NoPixel employee who was responsible for alleged data breach, accusing DW of being responsible for the breach. Now, this is actually about to catch DW at a surprise or coil surprise. This is going to be like a surprise attack right here. What I mean by a surprise attack, they're about to say something where things get weird. Okay. Things get 100% weird. Please be advised that the defamatory statements are objectively and probably false, as Mr. Tracy was never an employee of NoPixel. And I know you like,
hey yo, what the fuck?
Wait. What do you mean? He was never an employee of NoPixel. I've been paying this guy for at least 6-7 months now. I'm confused and could not have caused a data breach based on the authority Mr. Tracy had been granted to him as a developer of the game on the NoPixel server. Indeed, Mr. Tracy was not an employee of NoPixel because he is already gainfully employed as the lead developer for the company, which is Tove. It should also be noted that the game, in terms of Mr. Tracy's employment with the company, all of Mr. Tracy's contributions to the most recent version of the game, as it exists on the NoPixel server, is owned exclusively by the company and entitles the company to a claim from all such intellectual property. Now, if you're following this, you're like, wait, man, we just agreed that I would give him half of these 4 servers. He's making on the low end a base salary of 10,000 plus 20,000 splits. So 30,000 a month easily. And now you get a letter saying, no, he was never working for you. He was working for the company and we own everything he did. So they keep going on about the defamatory statements, about them harming his reputation. The statute of limitations are up, but here's their list of demands. Hey, remove any and all defamatory statements. Publish the statements on behalf of NoPixel and yourself, individually retracting the allegation that Mr. Tracy caused the breach. Cease and desist from any further statements or actions online that would purport otherwise advance a false claim that Tracy caused a data breach, and provide our office with written assurance of your completion to the above items within 5 days. Now, if you do all this, right, you're low key admitting you defamed him, but you could potentially eliminate a lawsuit. And this is why I say you have to make sure you never lie on someone. Okay? Because, people are getting sensitive now and everyone is sue happy. They give them a failure to comply. They may force us to use litigation. However, your actions in making discriminatorily false statements online have caused them damage. And they say this. Additionally, this letter is legal communication deemed strictly confidential. Guys, let me tell you this. Just because you get a letter in the mail that says confidential, unless you sign some NDA, it is not confidential. No one could just bind you to confidentiality because you received a piece of paper that says, hey, this is confidential. Okay, so they try to, send this, and John Bagakis, who is literally kicking Coil's back end, signs it. And then they send another one. You're like, wait. They did a follow-up. They did a follow-up one. You're like, wait, a follow-up one? Yes. So now he's about to be made aware that he's about to get sued for copyright infringement. And this is February 6, 2023, and the lawsuit got filed in April. Okay. So in short, they basically say, hey, look, we have the copyright. Okay. First, please be advised that we now represent That One Video Entertainment, LLC, a California limited liability company, to which respect any claims it may have against NoPixel for copyright infringement. For reference, Mr. Tracy entered into an employment relationship with Tove on or about October 14th, 2021, which is several months after he started working for NoPixel. And it is pursuant to this employment agreement that Tove believes it presently possesses a claim for ownership of any of Mr. Tracy's contributions to the development of the game as it exists on the NoPixel server, therefore as currently stands now All claims of IP ownership will be discussed hereby in connection with both of our clients' respective claims against NoPixel. So now you know the heat is on, guys. You get this in the mail, you like, wait, what the fuck is this? They're claiming that they own his work. At this point, you got to request a lawyer. You got to get your own lawyer to kind of get ahead of this, because they are not playing games. They've already invested in a lawyer, and they are this is like, hey, I just want to let you know, we're about to be coming for half that based off the fact that we own everything he did. So they keep going. Likely understand the utter disingenuous of your assertion that Mr. Tracy did not provide any creative contributions to the game. So basically, Coyle was like, he didn't provide any creative contributions to the game, so you guys don't really own nothing. Now, look, it's unfortunate that Coyle is caught up in this, but his story is about to keep changing for the most part. You also contend that whatever Mr. Tracy did contribute was perpetually licensed to NoPixel via its user's term of service. However, Mr. Tracy did not create a standard user account through the NoPixel website, as evidenced by the fact that his account name is DW, contained too few characters to be registered as a new account through the site. So now they're like, look, he's trying to pull the, hey, he agreed to the new service agreement. So the new service agreement, which is going to come into play, says we own everything. And they're like, he never agreed to your terms of service. So now you got to be like, holy shit. How did we slip through the cracks of this? Okay. So you have that. Instead, Tracy's account was manually created by another member of NoPixel management because Mr. Tracy was, by your own tacit admission, lead developer of the game, unlike other developers who worked on NoPixel server. However, Mr. Tracy did not sign an NDA or any other type of documentation that would have conveyed any rights to his creative contributions to NoPixel. So, I hope you guys see it. What's going on? Like the stream. I see the numbers went up, but the chat staying the same. Crazy. Anyway, first of all, foregoing reasons, Tove believes it possesses significant copyright infringement claims and absolutely intends to bring such viable claims against NoPixel if Mr. Tracy's reasonable demands brought way for the initial January 9th correspondence are not met. Unlike Mr. Clout, Tove is loyal to those who contribute to its success and is prepared to do everything possible to aggressively protect its interest of Mr. Tracy, including by way of its own infringement claims if necessary. So they're like, look, man, you ain't respond to the demands that we wanted you to, take back your statements. We're about to probably make a claim that you violating his copyright infringed on his work. Okay. Keep going. You also claim that on December 28th, Tracy was terminated from his position with the NoPixel server. You have provided no evidence that this alleged termination was formally made or that Mr. Tracy even knew such termination had occurred to put him on notice that any further access of the NoPixel server will be authorized. So now you see how they're stacking it up. They're stacking the case. Hey, we own his stuff. We didn't sign your terms of service. You fired him with no notice or no proof of it. This is 100% going to come up later. And we also feel compelled to point out, given in such evidence will be presented in any lawsuit brought against NoPixel, that your characterization of NoPixel as merely endeavoring to consistently and cautiously be compliant with the state, federal, and other applicable laws, in stark contrast to NoPixel's prior approach to actual data breaches. Indeed, in or about August of 2022, an individual, now they're about to snitch on NoPixel, scrape NoPixel's APIs, used unauthorized credentials, and obtain personally identifiable information concerning various members of the NoPixel community, including, without limitation, emails, Twitter handles, and NoPixel failed to notify the NoPixel community thereof. While our office in possession of evidence of the breach itself, please also be advised that NoPixel has actively deleted Discord communications with Mr. Tracy evidencing NoPixel's intentional and deliberate decision not to notify the NoPixel community of such a breach in violation of California's Discovery Act. So basically, in short, if you get hacked, you got to notify everyone. If you don't notify everyone, then you got stuff like this where they're like, hey, we got proof that you got hacked and you never notified anyone. I mean, we not gonna snitch, but we might. You know what I'm saying? It's like, you don't want people to know this. Okay. So they're still pushing for, hey, we need your response within 5 days. Now let's go to the motion. Okay. So all of this is literally about this motion right here. Okay. This is about Tove wanting Coil to produce financial statements and DW wanting, Coil wanting DW to produce communications. Now I see the people who are aware is like, holy shit, this is real. Yes, DW is cooking, because in court of law, it's not what you know, okay? It's what you can prove. And right now, Coil cannot prove much. So now he's going to the judge and be like, Judge, we need them to produce documents. And Coil's team and DW's team is like, Judge, we need them to produce financial records because we need to know how much money we potentially are out. And we know Coil already lost the motion to dismiss the case, so we will get to the trial date. Okay? All right, so now look. Basically, this summary, guys, it's just more of the same. It's more of the same, okay? Both parties is one evidence from the other. And basically what happens when you ask for evidence, everyone just objects. They object, and both of them will cry to the judge. And then the judge will make a decision on who has to produce what. And they give this summary. This background is just basically the summary of everything that we've previously discussed as far as, Coil hiring DW. The defendants denied this allegation that the defendant Clout attests in May 2021. Defendant Coil entered into a contract with Tracy, not Tove. So this is this whole semantics thing where it's like not even a thing. Coil's like, look, man, I was talking to Tracy. I never worked with Tove. Tove is coming out the woodworks like, Ninja, we got a contract with DW, which you guys will see the contract with DW coming up. And whether Coil knew about the contract or not, the contract that Tove has with DW looks to be legally binding. With Coil not having a contract, he's in danger. Now, it's all great that you got this Discord message saying that he'll get 50% from this server, from that server, and, all these new servers. But that doesn't matter. Okay. During the aforementioned agreement, Coil is like this, man. This is actually Tove, because Tove said we didn't enter into an agreement until October. So during the aforementioned agreement, when DW first started working for Coil, Tove did not execute an agreement stating that Tracy's contributions were works made for hire or were otherwise owned by the defendants. Okay. I see people are going back. People are behind and they're catching up. All right. That's fine. Okay. Specifically, Tracy designed and created the entire payment processing system utilized by NoPixel server, which has facilitated processing of millions of dollars in payments. When I say millions, we talking millions. We probably might be talking over 100 million. That's how valuable this company is. And people like, you just play games on the internet, bro. Him playing games on the internet is crazy, making crazy money. Okay. So plaintiff's first claim for declaratory relief essentially seeks a declaration that the plaintiff is the joint owner of the NoPixel server and Tracy 50% of the revenue from the aforementioned four servers, which is typically around $40,000 to $50,000 per month. Okay. Why do people hate Coil, guys? Look, I don't know Coil. I don't know DW. I'm just a court docs guy. I'm just reading this and giving you my interpretation. But, I do show every page so you can like pause it and go through and just watch it yourself and read it. Okay. All right. So look, this is where we're at right here. Right. This is where they're fighting over. On or about April 8th, plaintiff served defendant Coyle his first set of requests for production of documents, which is, this issue. Defendant served his initial response to document request on May 8th. On May 9th, plaintiff's counsel emailed defendant counsel regarding asserted deficiencies in defendant's responses for document request. Defendant served supplemental responses to the plaintiff's document request, but continued to refuse to provide any financial documents responsive to the request for production, asserting that such documents were unrelated to this litigation. Remember, they like Ninja, Coil, give us all the goddamn financial records. We want them all. We want to see every goddamn thing. And Coil was like, no, man, we give you the stuff from the 4 servers and leave us alone. They like, oh, so we got to go to the judge. Oh, okay. We'll go to the judge. So let's hear the decision and rulings, okay? So you're about to hear the judge's decision. All right, they're going to say, look, the plaintiff called for Coyle to produce all documents evidencing all money generated and cost incurred from your operation of the NoPixel server. I know this gotta sting, man. It has to sting when someone who doesn't even work for you anymore is like, hey, give me all your financial records. And you like, no, I'm not giving you all my financial records. Defendant initially interposed multiple objections, asserting that it's burdensome, oppressive, overboard, compound vague, pretty much every excuse under the board, even called it ambiguous. Okay. But now, plaintiff has not supplied the court with the actual documents requested, which presumably define the capitalized terms as the term NoPixel server. All right, now the court is about to come in. The court proceeds on the assumption that it has been defined in the manner consistent with definition thereof in the first amended complaint. It refers to a video game server herein and individuals who play it. The open world video game entitled GTA 5 can role play with other individuals in a closed game environment such as the server. But given the information supplied by defendants regarding multiple servers, further presumes that even though the term is singular, the NoPixel server, it's actually comprised of 172 servers. Sorry, guys, I said 670. It's 172 servers, including 4 specific servers identified by the defendants. Now, how many of these are paid servers? Because we know the four ones is generating $40,000 to $50,000 per month, just those 4. So when you have 170 of them, I'm not sure they're all paid, but god damn, this ninja got money.
I got money.
I don't know where they're getting 172 from. A statement. But they got these preliminary statements, but let's go to the court's decision. Okay. What do you think the court said? What do you think they said? What do you think they said? As noted above, NoPixel is GTA 5 online. Think of that. But you can role play as the characters. As noted above, defendant takes a position that his only agreement was with Tracy, not Tove, that such agreement only required Coyle to pay the defendant and defendant did pay Tracy until Tracy's termination in December. $10,000 per month plus 50% of revenue from India, Coyle whitelist span in South America servers. And at no point did the defendant's owner, founder Clout, ever speak to Tove. Okay, defender Clout represents that he agreed to give plaintiff revenue statements for the 4 aforementioned servers, which they list, but defendant declines to agree to produce revenues from any other servers that as they are completely outside the scope of the agreement at issue. Now, remember, this is about to be the court chiming in. Okay. Plaintiff essentially argues that defendant's response is insufficient because defendant's production does not include documents evidencing all revenues generated and costs incurred from the defendant's operation of all servers that essentially constitute the NoPixel server and is instead limited to documents evidencing revenues generated / cost incurred from only those servers that are defendant contends are relevant to the action under the defendant's theory of the case. Now, plaintiff contends that the request discovery is relevant to the production in the needs case because the First Amendment complaint alleges that the plaintiff is co-owner in the copyright of the code comprising of the NoPixel server and is entitled to 50% revenues generated, therefore, pursuant to the parties' agreement. And because the scope of the plaintiff's ownership and right to profits is broad enough to entitle plaintiff to half the monies reflected on the requested documents. Like, can you guys imagine this? You create a business that's generating $40,000 to $50,000 a month, and someone you fire is coming back like, I won't have. I wouldn't give one of those servers. Well, it don't work like that. You can't just say, black, no trade back or whatever. Okay. And so look, the court. Now look, I've seen plenty of these court documents, and I know when Coyle was reading this, he had to be pissed. And typically when you looking for a judgment, you just scroll to the end. You want to see what they read. Now, when you see the court, this is the judge. So the judge is not unsympathetic to the defendant's position, particularly given the evidence is submitted regarding relatively narrow agreement with Tracy versus the absence of any evidence submitted by the plaintiff to support its different broader allegations regarding the parties to in the terms of the agreement issue. So the court is like, we know they have no evidence that the agreement was bigger. We know this. However, they're like, however, as relevance is determined by reference to the pleadings, here the First Amendment complaint, the court is compelled to conclude that documents evidencing revenues generated and cost incurred from the defendant's operation of all servers that comprise the NoPixel server is relevant to at least the damages assessment for the breach of contract claim and accordingly overrules defendant's relevance over breadth objections. So it's like, God damn. I have to keep reading so you guys know what this means, right? Or you're putting it together. You're like, holy shit. Holy shit. All 172 servers? Like, yeah, Ninja. Yeah. To the extent the defendant stands on other objections, the court likewise overrules such objections as the request for reduction does not appear to the court to be compound, vague, ambiguous, unintelligible, as the defendant has submitted no evidence responding to RFP number 16 would unduly burdensome or oppressive. So you see where it's going, right? So they say, in light of the foregoing, court grants in part and denies in part motion to compel to further production. RFP 16 and orders defendant, so they're ordering Coyle to the extent that it has not already done so to produce documents sufficient to evidence the total annual revenue generated and total annual cost incurred from Coyle's operation of all servers comprised of the NoPixel server, not from 2020 to 2021 to 2022 to 2023, and documents sufficient evidence total revenue generated and total cost incurred from the first and second quarters of 2024. So if I'm Coyle, I'm pissed because that's a lot of work. So Coyle is low-key getting smoked right now. It's like, it is like a low-key, a pack watch, I know when they got this. Now let's go to Coyle's. Now, Coil is just like, look, man, we just want all the communications between Tove and Tracy that reflect the following subject. Okay. Tracy's employment status with Tove, employment agreements with Tove, Tracy's immigration status. This immigration status is going to come up later, I promise you. Any agreements with Coil, any agreement with Clout, any work performed by Tracy for Coil, any work performed by Tracy for Clout, payments from Coil to Tracy, payments from Coil to Tove, payments from Tracy to Tove, and payments from Tove to Tracy. Okay, so he's like, you know, he like, we just want the communication because right now, if you've been following the case, Coil is like, we had no idea of Tove. I only heard of them during this lawsuit. So you like, wait, what? I know you like, wait.
Hey, yo, what the fuck?
What you mean you only heard of this lawsuit? Like, look, bro, I only deal with DW. This Tove shit just came straight out of nowhere. You're like, oh my God. Oh my God. So long story short, okay. The court is like, okay, Coil, we just smoked your ass on all your financials. We will compel. So they, you know, the court is like, look, we'll make them provide you with the evidence. Okay. The court holds plaintiff to such representation. Further, the fact that Tracy stopped working for Coil in 2022 does not mean he did not communicate with Tove about such employment thereafter and does not obviate the relevance of any post-2022 communications with Tove regarding the same. To the extent he did, such communications are relevant for these reasons, argued by the defendant, irrespective of any privileges, assertions to which, you know, separate independent issues, yada, 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 turn over the goddamn communications, okay? So Coil gets a win, okay? So they're like, look, he has to turn over, the Tove has to turn over all documents in his possession, custody, or control responsive to, number 2, including post dating 2022, except those which assert, you know, attorney-client privilege or common interest privilege. 2, privilege logs corresponding with held documents to the complaint. It's so ordered. So this is part 1 of a 3-part stream today. But it's going to be, guys, probably a 3-stream part. When I say I'm gonna have to be streaming for like 3 days, NoPixel, to catch you guys up.
A few moments later.
DW immigration status is about to come up because Coil is seemingly looks to be losing the lawsuit. So they say, you know, Tove's lawyer says in a transparent and desperate attempt to intimidate Tove into dismissing its claims, particularly as it become more apparent that Tove is clearly entitled to co-ownership in the copyrightable work at issue in this case, defendants have turned to accusing Tove of committing immigration fraud. Like, immigration fraud. After improperly threatening Tove's principal with up to 10 years in jail time, okay, on such an utterly baseless accusation, defendants served the subpoena on plaintiff's immigration counsel to obtain their obviously privileged communications with Tove's principal. God. So now they're like, all right, Ninja, we know y'all doing some illegal stuff, okay? Okay. So we know the underlying dispute is, do they own the company? All right. Does Tove own half of it? They cite, hey, like in or about early 2020, NoPixel desired to engage Mr. Tracy in his role as software developer to make significant updates. So we know that. We know that they hired him, okay? We know that he rendered services to them, okay? But Tove is like, look, they want to share in the profits because they're co-owner of the copyright. Okay. The deposition, they deposed some people. Like, hey, what's going on? What's going on there, guys? What is going on? They deposed the people. Hey, y'all ain't tripping. Henry is Jim Jones and David Koresh rolling into one. Goddamn. God Not Jim Jones and David Koresh. Like, Jesus. David Koresh was like, he was horrible. My criminology, we had to study that fool. We had to study them. Okay. All right, let's get to it. Okay. Defendant counsel presented Mr. Khalil with immigration forms, which Tove had submitted for Mr. Tracy to obtain a work visa due to his employment with Tove. Okay. And look, they talk about this on or about July 12, 2024. Defendant's counsel took the deposition of Jackie Khalil as a chief CEO of Tove, the person most knowledgeable on to testify on behalf of Tove. During the deposition, defendant's counsel presented Mr. Khalil with immigration forms to which Tove had submitted for Tracy to obtain a work visa due to employment with Tove. After asking a series of questions regarding Tove's employment of Mr. Tracy, defendant's counsel, who has since admitted to having absolutely no experience in immigration law, accusing Tove and Mr. Tracy of committing a scam to the immigration department. So now they're saying that Tove scammed the immigration department to get DW's visa. Okay, to get it. You like, wait, man, this is getting wonky. And they got, look, hey, they like, hey, Exhibit A. Okay. So they like, look, on or about July 15th, defendant's counsel sent Tove's counsel an email correspondence wherein he demanded that Tove immediately dismiss its claims because Mr. Khalil knowingly furnished false information subjecting him up to 10 years in prison. So they're like, look, Ninja, you fudged DW's immigration paperwork. And that's punishable by 10 years in the goddamn clink. And shout out to Shooter Torres again, who says, I'm not wearing purple sneakers, Henry. What color sneakers you wearing? Shooter? Yeah, I'm saying, what color you wearing, Shooter? So they attached the email where he like, yo, you going to jail for 10 years, Ninja. So he like, wait, what? 2 days later, July 17th, defendant's counsel also sent essentially the same threatening email correspondence to Tove's immigration counsel at the law firm of Jackson Lewis and harassingly called such counsel multiple times. After those threats did not work, defendant served Jackson Lewis a subpoena seeking all communication between Tove and counsel. So you're like, man, look, this is a Hail Mary. Okay. This is a Hail Mary. So the parties have properly met and conferred. During this meeting, defendant's counsel admitted to having literally no experience in immigration law. So they met on the July 22nd. Yet defendant's counsel again threatened Mr. Khalil of Tove with criminal prosecution, stating your client is going to jail if Mr. Khalil did not withdraw the complaint. So it's kind of like, if you don't drop this lawsuit where you're seeking half the ownership of NoPixel, we're going to tell the immigration status you lied. So they're basically saying, hey, this subpoena must be thrown out. Like, we should not have to abide by it. Okay. They're like, they're going to make an argument that everything with DW's immigration status is on the up and up. And even if it's not, that has nothing to do with the lawsuit. Okay. Nothing to do. Defendants do not hide what they seek via subpoena, privileged email communication between Tove and immigration counsel. But whether because defendant's counsel truly believes such information is relevant and not right for exclusion at trial via motion to lamine, or whether defendant's counsel has become desperate to not lose, he is willing to try anything. The attorney-client privilege absolutely protects all of such communications between Tove and its immigration counsel. Knowing this, defendants attempts to allege the crime fraud exception, but the court will see below such exception does not apply. Okay, all this immigration. Look, guys, this is not over just a GTA server. You're talking about this is like potentially $30,000 to $50,000 per month. Okay, of revenue. All right. So they go over the crime of fraud. They give you some statutes, and they basically say, Mr. Tracy's plaintiff's principal submitted a false information in connection with a H-1B application regarding Mr. Tracy's place of employment and 2, the percentage of time Tracy spent on certain work. First, Tove's answer in the negative to question the form 935 whether Mr. Tracy would be placed with a secondary entity at this place of employment was accurate. This is because the question stated another way is simply asking whether Mr. Tracy would be physically placed at a work site that was controlled by a third-party business for which Tove was providing his services. The declaration of Benjamin Liu, the answer to that question was accurately no, because Tracy was working remotely for NoPixel during his employment to Tove. Declaration of Tracy. Second, the letter submitted by Tove's principal, Mr. Khalil, as part of the H-1B-I-1 application specified that approximately 10% of Mr. Tracy's job duties would be to create video tutorials, demonstration software, modifying techniques, and general media content, discussing software modifying strategies for interactive multimedia entertainment productions, Lou DeCal. A portion of Mr. Tracy's time as an employee for Tove was dedicated to streaming audiovisual content of Mr. Tracy's programming abilities in connection with a game played on a NoPixel server. While Mr. Tracy did stream more during the certain times than others, the 10% number assigned to streaming was an accurate estimate of the average amount of time Mr. Tracy would spend on such tasks given week at a time application was submitted. So basically what they're trying to say, and I see the NoPixel audience is coming back, like I see the numbers go up and down, is, hey, DW lawyer is saying, no, we accurately filled out his application. And Tove's lawyer is like, no, you didn't, because you didn't. I mean, Coyle's lawyer is like, no, you didn't. You didn't fill out the application. It's fraud. And the part you missed out is how he's spending his time. So it's kind of weak, but it's like, look, man, they trying to get something. They're trying to get something on them. All right. We don't need to go through all of this, but there is some parts where you're about to see Larry Zerner pop off. Okay. He's about to just pop off. And what I'm doing is I am scrolling slow enough. So if people want to read this and people want to go over it, they can. Okay. So he does that. Let's go through the declaration of John Bakakis. Now, this just reaffirms what we already know. He's an attorney that works for, That One Video, a California limited liability company. Yada, yada, yada. Mitchell Clout runs NoPixel. And let's get into the good stuff. On or about July 12th, the defendant's counsel, Larry Zerner, took the deposition of Jackie Khalil, an owner of CEO of Tove, the person most notable to testify during the deposition. Mr. Zerner presented Mr. Khalil with immigration forms, which Tove and Mr. Tracy had jointly submitted for Tracy to obtain a work visa due to his employment with Tove. After asking a series of questions about such forms, however, Mr. Zerner then accused Tove and Tracy of committing a scam to immigration department. Mr. Zerner, therefore, after continued to threaten Mr. Khalil with committing immigration fraud, which Zerner claimed was a crime with penalty up to 10 years. A true and correct copy of the relevant portion of Mr. Khalil's deposition transcript evidencing such highly inappropriate threats is attached. When we get to these depositions, you're going to laugh because you're going to see people just fly off the goddamn handle. You're going to be like, what the hell? All right. So all of this is important. Oh my God. So peep what Coyle's lawyer is doing. Okay. Is Coyle winning? No, he's not. On or about July 15th, 2024, Mr. Zerner sent an email wherein, he demanded that Tove immediately dismiss the claims because Mr. Khalil knowingly furnished false information, subjecting him to up to 10 years in jail. A true copy of Mr. Zerner's email correspondence is attached. On or about July 17th, I received the email from Benjamin Lau saying Mr. Zerner pretty much did the same thing to me, saying, hey, delete the case. On or about July 19th, I received an email from Mr. Zerner stating that a subpoena seeking attorney-client privilege communications between Tove and his counsel, Jackson Lewis, had been served. So he's gunning for him, right? The next day, July 23rd, Mr. Zerner came to my office to meet and confer. Confer is just talk. During this meeting, Mr. Zerner looked me in my face and said, your client is going to jail, which is Mr. Khalil, if he did not withdraw the complaint. Mr. Zerner also told me that he had literally zero experience practicing immigration law. Ahead of the meeting, Mr. Lau had provided us with the responses to each of Mr. Zerner's claims regarding Mr. Khalil's supposedly fraudulent statements, and I tried to discuss those responses in good faith with Mr. Zerner, but Mr. Zerner refused to listen, much less agree to even narrow the scope of the subpoena. A true and correct copy of the email that Mr. Zerner mentioning the more egregious parts of our confer meeting is attached as Exhibit E. Like, bro. So they want to squash this subpoena, okay? So they're like, look, man, he's basically threatening people, saying they're going to go to jail, okay? Oh, God. All right, so when you see this right here, this is a deposition, okay? This is basically a court reporter recording things, okay? Okay. Now, look, do we need to read every word in this deposition? Absolutely not, okay? Absolutely not. Mr. Zerner starts. One that's called immigration document. Mr. Bacchus got it. Witness, I got your email and I'm looking at them all right now. Immigration documents, plural. Yeah, it's a 16-page document. Immigration document 912. Labor condition, like, let's get to the good stuff. Let's get to the good stuff. Okay. All right. Right here. So now look, here we go. Here's the question. It doesn't help your business at all. Forget the money. It doesn't help your business if he's developing for NoPixel, correct? Objection. Vague. The witness is like, look, I would disagree. I think notoriety is a big deal, especially in our industry. People found that he worked for us and they knew that it was related to the completionist. Mr. Zerner says to Mr. Khalil, tell me if this is correct. Danny wanted to stay in the United States. He couldn't stay in the United States if he was working full time for NoPixel because NoPixel is in Australia. You fronted like he was going to be a developer for Tove, but in reality, that was a lie. He was actually going to be a developer for NoPixel. Then in exchange, he wanted to stay in the United States. And then you made an agreement that you would take his hush money, which is, they put butch money, the money he got from streaming or subscriptions or sponsorships, and then you would take the first, give back the salary that you were allegedly paying him to work for NoPixel. Then you take 30% on the top. And this was all just to scam the immigration department, correct? So if you don't see the picture that Coyle's lawyer is painting, he's saying, look, you guys only signed him up to work for your company so he wouldn't leave. In exchange, you took the money he gave you and gave him a salary to satisfy all things with immigration. Now, what do you guys believe? All my NoPixel fans that are recently here, do you think that DW start working for Tove to maintain his immigration status, and in exchange, they would take 30% of his earnings? Because that's literally what it is. Like, hey, he needs a job to stay working here on a work visa. And Tove is like, well, we're not going to sponsor you for free. You're going to work for us through NoPixel. Now, his lawyer objects. He says argumentative, calls for a legal conclusion, assumes facts not in evidence, and potentially requires disclosure of attorney-client privilege to communicate. Now, this is just standard. To the extent that you understand the question in that rambling 2 minutes and you are capable of answering without disclosing attorney-client privilege, communication between you and your immigration counsel will do so. Now, the witness, when someone says objection, you'd post a stop. But what's happening is, Khalil like, nah, ninja, nah, I ain't letting that shit ride. He about to just say we running some operation to basically allow immigrants to stay here in exchange for their hard work. We give them a salary and take 30%. No. First of all, I take offense to that comment that we were trying to run a front or a scam. Danny wanted to dedicate more time to development on NoPixel. I hired him so he could do that. There were some beneficial upsides financially for both of us in order for him to do that. So Danny could not necessarily have to worry about his roles or responsibilities that he had to Grubhub previously. And he could dedicate full-time development work, which also included him streaming from time to time to getting on the phone with me to geek out about some technical stuff. Now, imagine this, right? Imagine going to working for freaking Grubhub to making $30,000 a month. Potentially 60 if you factor in what he was getting from Twitch. Oh my God, damn.
I got money.
Okay. So he was like, look, so to say that we're trying to front the scam, not only do I disagree with it, but I take offense to it. Like Zerner, look, man, he's literally about to start snapping. Zerner says, you didn't write in your letter that you were going to loan him out to NoPixel and work for an Australian company, right? Oh my God, damn. Oh man. Oh my God. Look, man, Zerner is doing his goddamn job. Okay. His lawyer reprints the same objection stuff. They be on like whatchamacallit, but remember, just because they object, the witness is like, no, I'll say this. I'm not aware that anything we did was illegal, if that's what you're trying to allude to. Now, look, you can call that shady if you want, but hey, he's like, look, man, I didn't do nothing illegal. So I'm not saying he gave us money in exchange. We gave him a salary so he could stay in the United States, because technically you can program in the UK. You don't need to be in the United States if you work in remote. So Mr. Zerner is like, just know that making material misrepresentation to the immigration office is a crime with a penalty up to 10 years. I'm just letting you know that. Like Zerner he just does not give two shits about anything. Okay. Now they're about to go send the emails. That was the interrogation. Zerner is like, look, I just want to follow up a little bit on our conversation this morning. Back in 2021, Jackie's filed the H-1B1 declaration, which was signed under penalty of perjury. Not only is it filed under penalty of perjury, but the document further warned Jackie that knowingly furnishing false information on the form attached is a federal offense punishable by up to 10 years in prison. So they like, hey, look, this is what's going on. In the application, Jackie was asked whether Danny would be placed in a secondary entity, and the answer was no. A secondary entity is defined as another entity in which the LCA workers will be placed during the period of certification. Okay, I mean, they show everything. They show him checking no. Okay, because now he's trying to allege some fraud in the immigration department. Then Jackie submits a letter in which states that Danny is being hired as Tove's lead developer. Mr. Farrell Tracy will be responsible for working as Tove's lead developer. The letter gives the approximate amount of time that Danny would be working at each task, and it adds up to about 100%. Nowhere in the letter does it say that Danny is being hired to work at Coil, nor does Danny's employment agreement mention Coil. Jackie admits that he never spoke to Mitch or anyone at Tove prior to entering into this alleged loan-out agreement with Coil, and that Coil paid Danny's salary directly to Danny, not Tove, and that to date, Danny has not paid any of his Coil salary to Tove. So hopefully you see what the hell is going on if you're following this case, okay? So he's like, look, we will be filing the motion for summary judgment, bringing up all of these undisputed facts to show that there never was an agreement between Tove and Coil, which I do have the motion. You can file a declaration from Jackie's claiming that Tove did loan Danny out to Coil, but in doing so, you run into at least two problems. First is the sham affidavit rule, which says that a party cannot create a triable issue of fact by filing an affidavit that contradicts a previous statement made under penalty of perjury. Second, and more importantly, if Jackie's were to submit a sworn declaration stating that Tove loaned out Danny to Coyle, or if stated this is on the stand during trial, he would be admitting that the statements in H-1B application were false, that he committed perjury, and that he would have violated a number of federal statutes. Even if Tove could have loaned Danny out to Coyle, and it didn't, it would certainly be considered a material omission from the application, not to mention that Danny would be spending a great bulk of his time working for a company in Australia. This does not even begin to consider the fact that Danny was actually making money for Tove by streaming, a fact that it's also omitted from the application, which also would be considered a material omission. Now, they keep going. Like, I'm telling you, Larry Zerner is not backing down off this shit. They actually have a hearing regarding this issue coming up in September. I understand that everyone wants to win their case, but just can't contradict sworn statements without consequences. The consequences in this case could be that Jackie's is arrested and charged with filing false immigration papers, and that Danny is thrown out of the country and never allowed to return. I sincerely hope you have adequately warned your client of these very real possibilities if the case continues. Like, this low-key is an intimidation thing, okay? Okay. Tove cannot create an issue of fact that completely depends upon contradiction earlier sworn statements. There is no reason for this case to proceed, and I would ask that you ask that immediately dismiss it. So he's trying to put it on there before you put your clients in a position where they are forced to admit to committing perjury in an immigration application. And just so there's no confusion, I want to make it clear, I'm not threatening to report Tove to immigration if the case is not dismissed, and I have no intention of contacting immigration.
Stop the cap.
It is you who will be bringing all of this up to a Judge Wilson, a former AAG who ran the division prosecuting tax fraud. If you think that Judge Wilson will hear this testimony and not take any action against your clients, then by all means proceed. But you should make sure that your clients are also on board with the risk. Like, bro, Larry Zerner is just going off. And look, they bring up the Larry Zerner emails and they show him that, look, man, this guy, Larry Zerner, is he telling them, like, look, what is this? This is them basically letting Tove know that, hey, we got an email from Larry Zerner and that we're going to be served with a subpoena. Basically, they'd say the same thing, that we got served. We're writing you about the visa application that we prepared for that one video on behalf of DW. And what else is going on? Coyle is currently in a lawsuit. Hold on. This is from Larry. This is from Larry again. So basically, Larry is saying the same thing to everybody. Like, hey, this application is wrong. Y'all gonna go to jail. Drop this goddamn lawsuit. I took Mr. Khalil's deposition on Friday. He proudly admitted that the statements in the immigration application were untrue. I don't know if they said that, Larry. I don't know if you said that, Larry. It might be a reach. It might be a reach. But this is what's going on because he was trying to get them to drop this lawsuit. Okay, it's more case law. I believe this is this it? What's the next one? This is a copy of the subpoena. Like, Larry Zerner is just he's out for blood. And this is how you want your client to be. Okay, so here's the declaration of Coyle regarding this immigration stuff. Declaration of Daniel Tracy, I'm sorry, in support of plaintiff's motions to squash the subpoena for the stuff, for the immigration stuff. So, he says, hey, I am DW. As part of my employment, I would spend a portion of my time streaming myself, rendering development services on the video game server operated by defendant NoPixel that hosted an open world video game entitled Grand Theft Auto 5. I know that I stated in my deposition that in the fourth quarter of 2021, specifically, I streamed approximately 25 to 40 hours a week, but I also testified in May I was only streaming a few hours a week. This is because the amount I would stream on any given week could vary. So he clarified some inconsistencies, signed DW. And wait, make sure I got this all. Yep, that's good. And this is also the person who filled out the immigration status. I am Benjamin Liu. I'm attorney licensed to practice law. They go on to confirm that, yeah, Larry is threatening us, saying that we put up false information regarding DW's employment, that Tracy would, be physically placed at a work site that was controlled by a third party business for which Tove was providing services. Since it's my understanding that Tracy worked remotely for defendants and was not physically placed at a third party work site, then the answer is no. So like, look, we filled this shit out, man. Larry tripping. It is what it is. Tracy is fine. The 10%, however, the visa included that 10% of Mr. Tracy's job duties would be to create video tutorials. They reiterate everything, but look, man, it does seem like Coyle is done in this case. When you start going after the immigration status, it's pretty much GG. Now, what do you guys think about them going for the immigration status? Now, look, here is the last one. Oh, man. Here's the last one. Now, here's the thing. It'll take me about 20 minutes to go through this. It is not the last one. It's their motion for summary adjudication. Now, here's the problem. Let me show you this. This is the motion for summary adjudication. It is 23 pages long. However, you have the second part, which is all their evidence, which is 108 pages long. Then you have, this is DW's statement regarding why they should win summary judgment, which is 7 pages long. And this is their expert, their forensic scientists, and it's 10 pages long. The problem is, if I cover this, I'll be talking about it for an hour. So what I'm going to show you, well, I'll show you, I'll give you a little sneak peek. I'll give you a little peek, you know what I'm saying, of this 108 page document with their evidence. It's a lot of evidence in here. I know you want to see the good stuff. So let me scroll to the good stuff, and we'll save it maybe for a video. I don't know. It's so much. I know y'all want to see like text messages and stuff. I got them. Okay. All right. So let's look at DW's agreement with Tove. All right. This is his employment agreement. Did DW win? No, but he's winning. Coyle is losing. Coyle is losing based on evidence. Now, remember, guys, in court, it's not what you know, it's what you can prove. Tove is suing NoPixel for half ownership of what started out as 4 servers. 4 servers. Okay? And Coyle tried to get it dismissed and lost. Okay? So now let's keep it going. Maybe I'll drop the link at the end, see if people want to come up and talk Power Rangers or this lawsuit stuff. But these are some random facts of their motion. They're basically filing a motion to say, hey, can you just say that we own half the company, half the servers, and we can start getting to accounting. Here's all of our evidence. So here's the company. This is the real exhibit. Dear Danny, your position, your initial title will be lead developer, and you will initially report to the COO, Jackie Khalil. As the company provides entertainment services, you will be required to appear on camera, create video tutorials, and general media content around the services you provide. This is a full-time salary position. You will be required to work a minimum of 35 hours per week and will not be eligible for overtime pay. You're like, all right, cool. Your salary is going to be $100,000. You're like, oh shit, sweet. you may be eligible for sponsorships during your employment. You may be eligible to participate in paid sponsorships for services you provide to the company. With respect to all such sponsorships, you agree that all compensation you earn is to be paid by the third party sponsorships entity directly to the company. So any money you earn is supposed to be made to the company. The company shall retain 30% of the gross amount paid for, and you shall get paid the remaining 70% of the gross amount paid for the sponsorship, subject to less the payroll deductions withheld and required by law. So off the top, they're like, Ninja, any money you make, we get 30%, which is, it is what it is. They talk about bonuses, expenses, NDAs, but here we go right here. This is the kicker. Ownership of intellectual property. During your employment with the company, any creative or intellectual property developed and originated by you in performing your duties for the company will be company property. You will not, without an express written agreement signed by the company, have any rights to the property. This statement right here is what Tove is using to say we own half of NoPixel, or bare minimum the servers that NoPixel agreed to give DW half the revenue for. So like, we own half that shit. Okay, he's the at-will employee, verification, identity, authorization, tax matters. No one really cares about any of this other stuff. But what you need to take away is that he owned it. Now, the crazy part is the signature. Remember, DW start working for Coil in May. Okay? I believe it was May of 2021. And here's DW's signature in October. So they're like, okay. Now we keep going to their exhibits. This is how DW's account was created. Hey, bud. Hope the wedding honeymoon is well. Gucci. Have a bit of an annoying request to ask when you are back and settled in, if you wouldn't mind. On this, I was wondering if you could do me a solid and change my forum Discord login name from DWDW to DW. I could only limit it to 3 characters when I first signed up. Han says, send me your profile. He sends it. It's changed. DW. Thanks. Had to rejoin the Discord for the name to take effect. If you wouldn't mind adding. Okay, so there goes the whole I bypassed the TOS because someone else created my account. Because the new terms of service, which you're going to see at a later date, involves anytime someone joins, anything that they do, make, own is their property. Okay, so here's the receipt for the logs. August 16th, 2020, or April. Wait, was it? Hold on. Accepted terms and rules, April 22nd, 2020. Username DWDW, August 16th. Remember, he's saying, hey, I never did any of this. So it is a possibility that someone may have accepted the terms on his behalf when they created the account. But that's neither here nor there. Now here is the deposition of Mitchell Clout for all my Coil people. That's in here. It's interesting because there's a lot of parts in here that they highlighted. So question, and the definition is when I say terms, role play server or NoPixel server, do you understand? I mean that private version of the game run by a collection of different servers from which users apply to participate in an immersive game. Yup. All right. So this is literally the beginning. Well, I don't know if this is the beginning, but they included all relevant pages. Han part owner. Well, he's in the part lawsuit. He might be, his share may be getting cut. Okay. So they ask him a bunch of questions. Now, look, we have page 44 of 108. I really don't want to go through all of this, but we can go through some of it. Okay. When I say Now he's asking Coil this. So let me clarify again. When I say the back end, I mean the back end with respect to your version of the game and played in an application only closed universe version of the game on the server. So yes, of course, there is a game created by somebody else that I'm talking about. The NoPixel server backend and the entire NoPixel server backend. You understand that, right? Coil responds, yeah, right. And it utilizes other people's code. Now you see how he's trying to throw out this other people's code? It utilizes other people's code. So yes. If there's stuff updates, we have to update too. So if it's outsourced stuff, then yes, it's people that are assisting, and I guess, but otherwise it's purely NoPixel modifications. Then not that I'm aware of. No. Okay. So for version 1.0, would you be aspiring community member apply to become part of the community? I recognize that I think at one point you testified that it was an open world. So would it become a whitelist to use your testimoniology with the process somebody to become part of the community? It's the same process as Arma. Since Arma was also a whitelist server, they signed up to NoPixel.net, they apply, then they either get accepted or they don't get accepted. Okay, so they would go to NoPixel.net, and there would be a page that would tell them how to apply. Yep. Like it's like this is just like I don't know, background questions. This is not the real juicy stuff. The juicy stuff comes way later in this deposition. But when I tell you like everything that he said is pretty much in here that's relevant, you like, God damn. Okay. Let me see if I can find one juicy part, then I'll shut this joint down. All right. Let me make sure. 52, 53. Okay, so let's do this one. Testimology. Look, that's what they put in here. What you want me to do? You're like, wait, did you read that right? I'm like, no, I read it right. It said testimology. All right, hold on, guys. I want to get to like a juicy part, like something really juicy. I read most of this. I'll be honest. A lot. I read the part where Coil got fired or DW got fired or he quit. But like they're putting in all this. Remember, they're trying to secure the bag. Jesus. Okay. All right. Here goes a good question for you guys. How many people do you think is on the server? Best estimate, thousands, I'm sure. I know the registered members alone were over 500,000 a while back. So it's probably 600,000 or 700,000 people that are registered to play NoPixel. That's a lot of money, especially if even half are like paid priority on the lowest tier. Okay. Whitelist is 250 to 260. I believe there was like some part where it's like, oh, you just have to know a streamer. You can get whitelisted perhaps, or be a streamer. All this other stuff, but we're going to cap it off right here, guys. But just know the next time we fire it up, we're going to go through more of this. The motion for summary judgment, which is, well, this is DW statement. And this right here is the banger. Now, remember, they have a hearing September 9th, 2024 regarding the motion for summary judgment. And they will testify to see what is what. Like, it'll be the biggest one, because if DW or Tove wins, then we talking settlement. And also, Coil has filed another motion to dismiss. So if that fails, then it's settlement. I can't see them going to trial because the judge is just cooking them. The problem is Coil has no proof of certain elements, in my opinion. I'm not a lawyer. You can look at the court docs. You can make up your mind for yourself, and let me know in the comment section what you think. And I'll see you in the next NoPixel video. Peace.